Miranda versus Arizona, breaking the barrier between self-incrimination. On March 13, 1963, Ernesto Miranda's truck was seen outside of a home of a small family with an 18-year-old daughter. The police arrived, and that's when he was accused of both rape and kidnapping. He was not told of his rights and was immediately taken to the jail to be lined up and interrogated. He was confirmed to be the suspect. In interrogation, Miranda was still unaware of his rights, and no attorney was present to defend him. In 1963, Ernesto Miranda was convicted of both rape and kidnapping. However, his case was first put into question because he was not aware of his rights. Miranda versus Arizona broke criminal rights barriers in history and left America with fuller protection from both the Fifth and the Sixth Amendment. Leading to this case and to support the defendant's argument is the Fifth and Sixth Amendments, written in 1791 to say people cannot incriminate themselves and everyone has the right to an attorney. Attorney John J. Flynn explains
that he had the right not to incriminate himself, that he had a right not to make any statement, that he had the right to be free from further questioning by the police department, that he had the right at the ultimate time to be represented adequately by counsel in court, that if he was too indigent, too poor to employ counsel, that the state would furnish him counsel.
Another important event leading to this case was Juan versus the United States in 1924. When Juan was forced to confess his actions, it did not begin the case with representation. It ended up being dropped because it went against his Fifth and Sixth Amendment rights. The court recognized the right to counsel now not only entitles the accused to counsel's advice and aid in preparing for trial, but stands as an impenetrable barrier to any interrogation once the accused has become a suspect, and later, that counsel is constitutionally required whenever he would or could be helpful. The case also recognizes that in the federal courts, the requisite of voluntariness is not satisfied by establishing merely that the confession was not induced by a promise or a threat. A confession is voluntary in law if and only if it was, in fact, voluntarily made. Another major case was Escobedo versus Illinois in 1964. This was when Escobedo was denied an attorney after asking the court for one. The judges recognized that the suspect has requested and been denied an opportunity to consult with his lawyer, and the police have not effectively warned him of his absolute constitutional right to remain silent. The accused has been denied the assistance of counsel in violation of the Sixth Amendment to the Constitution. And lastly, Miranda's first case, in 1963. He did not have an attorney for this one, and was convicted because of a signed confession that was forcefully taken from him. Attorney Flynn tells the court,
The form handed to him to write on contained a type statement as follows, which precedes his handwritten confession. I, Ernest A. Miranda, do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me.
However, this signed confession was most likely not voluntarily taken from him.
Back then they had a problem with police interrogating people using something they used to call the third degree, where they were allowed to beat them up or yell at them or hold them in a room for hours and hours and hours. And so if I had been the attorney for Miranda back then, I would hope that I would do the same things that his lawyers really did do, which is question, wait a minute, getting somebody, torturing somebody or coercing somebody into confessing maybe means that they didn't really do it. Maybe they just said they did it to stop the pain. So I hope that I would have done the same thing that those lawyers did, which was go into court and object and say, hey, we got to stop this.
Mr. Borland and Miranda's lawyers agreed on the same idea. Miranda's defense appealed for years and finally got his case to the Supreme Court, where they could fight for his constitutional rights. The head of the bench was Supreme Court Justice Earl Warren, the former governor of California.
Well, I wouldn't have been surprised back then in the 60s because it was a big problem. And everybody knew it was a problem. And especially in the area where Miranda was at, I think those lawyers were waiting for a perfect case to take up to the Supreme Court. And so I think they saw every day that people were abused and harassed and tricked into confessing to things that they didn't do, or even things they did do. And probably the lawyers that did this every day saw it all the time.
Going to the Supreme Court gave attorney William A. Norris the perfect opportunity to share his opinion on what would soon be the Miranda rights. He told the court,
I think for one man, a warning might be effective. For another man, an experienced criminal lawyer, a warning might be unnecessary. Still, for another man who really isn't capable of making a judgment even with a warning may not be enough. I think that's a factor to take into account in determining whether he has made the knowledgeable and intelligent waiver of his constitutional.
The case ended in 1966, and though Miranda was sentenced to 20 to 30 years in jail, then put on parole, lawyers still considered the case as a win because it changed criminal rights laws for the better and called attention to the issue of self-incrimination and the lack of proper defense. Norris's voice reached the judges, and after a close decision of 5-4, the Miranda warnings were enforced in the United States beginning in 1968. However, they do not have to be read to the suspect. The memorandum is the takeaway of the court case and is written after all the final decisions have been made. This says, the person has a right to say nothing and a right to counsel, and later says, he must also be advised of his right to free counsel if he is unable to pay. In Miranda's case, he was not able to pay for an attorney, so the court appointed him with one.
Miranda rights to you if they want to ask you questions and if they want to be able to use what you said. So if you got arrested for something that they don't have to question you about, right? And if it's a murder investigation, they really want to talk to you. Where were you? Why were you there? Who else was there? What were you doing, right? If it's a possession of a drug case, they don't care what you've got to say. They caught you holding onto a drug. They don't need to ask you questions. They don't care if you confess or not because they have you and they have the drug. That's all they need. So they don't read them to everybody, and they don't have to. A lot of times they will just in case. Sometimes if they're putting the suspect into a car to take him somewhere, right, because they've arrested him, they'll go ahead and read them to him just in case you start saying something while you're driving in the car to the police station. They don't have to. I think there should be a better warning that's even better than Miranda that they should have to read to everybody that informs them of what their constitutional rights are, right to them.
They are. You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you in the court of law. You have the right to an attorney. If you desire an attorney and cannot afford one, an attorney will be obtained for you before police questioning. Miranda v. Arizona breaks major criminal law barriers in the United States. The case called attention to the holes in American rights and patched them up by fully enforcing the Fifth and Sixth Amendments. Miranda did go to jail, but as the saying goes, you do the crime, you pay the time. However, he set the example to speak up about personal rights for a fair case. Because of the Miranda v. Arizona case, Americans are fully protected from the Fifth and Sixth Amendments, whereas before, the rights these provided were rarely practiced correctly. He and his team of attorneys act as inspirations for those who are looking for criminal rights justice.